Okay, assuming the clock is right, we're live at this point. So first, let me thank you for joining me on the graveyard shift here today. I know there's some serious social networking going on outside, and I appreciate your willingness to hang in there. Let me take a quick census. How many faculty in the room? Zip. Okay, how many law librarians? All right, and the rest tech folks? That a fair description? Okay, good. Well, there's some utility here, I think, for all of you, and let me cast it in the way that's most helpful to the majority of you. When folks are, well, no, one more thing. There are support materials for this discussion. This is the website. It's mmcdiarmid.net.com will also get you here. In addition to the stuff that I'm showing today, there are some videos, there are some tutorials, reading lists, etc. So if you're going back and wanting to talk to clinicians at your school about how this stuff might work for them, that's a resource that's available to you, in addition, obviously, to the CALI conference website materials. When folks are teaching in the clinical context, they're frequently trying to teach various sorts of lawyering skills. Some of the basics are obviously trial advocacy, which is sufficiently robust that it generally shows up in a separate course in law school. But some of the others have to do with negotiation, with counseling, with interviewing, and with other sorts of lawyering activities. What I'm going to show you here today has application in those three. So I'm going to show you a negotiation application, I'm going to show you a counseling application, I'm going to show you a interviewing application. These are things that a student might learn for their development as a practitioner. There are also things that might be used to teach various skills to students in the clinical context. And we're going to start with, as soon as I wake up my machine here, we're going to start with negotiation. Obviously, one of the key problems in deciding whether one ought to accept a settlement or not in a negotiation, something that the other side is offering to you, is what could I do if I went to trial? What's my best alternative to a negotiated agreement is the catchphrase that was popularized by Fisher and Urey in their book, Getting to Yes. So what's my BATNA? What's my best alternative? In the case of litigation, that best alternative is almost always the trial option. Okay? If you were thinking about an international negotiation between countries, BATNA might be war. Right? The alternative to getting an agreement might fall into that kind of category. So what we need to do is we need to figure out what that BATNA is. And law students, and lawyers for that matter, don't have a lot of very good data on which to evaluate settlement options. So the methodology that is in common use in these kinds of activities is decision analysis, lifted almost wholesale from the business context, in which a business person might say, well, you know, I have 3 possible vendors. I want to evaluate my choices with respect to those vendors. When you're evaluating a piece of litigation, what you're trying to do is figure out, okay, what's the judge going to do? What's the jury going to do? Am I going to get to a jury? Am I going to get an earlier resolution of the case via summary judgment or some other way? And this is an example of a decision tree diagram. Basically what you're doing is you're taking probability times outcome to evaluate your various choices. Now, immediately when I say that, most of you realize that the vast majority of law students, let alone law faculty, are where they are because they hate math. Right? Right? It's the only graduate discipline in which you can reasonably expect to do well without having to add or subtract. Right? So you present students with this kind of schematic, even though, I mean, right, this is 4th grade stuff, right? Multiplication, freak, right? Just absolutely freak out. But it's the only way you can do a decision analysis. What you need to do is you need to do some multiplication and some addition to figure out what the probabilities of your various choices are. And I would go through these first couple of slides to show them how to do that process manually. We're going to skip ahead because you didn't come here to learn decision tree analysis, right? Okay. Where I want them to get to is the notion that you can render all of this into a spreadsheet program. And what are the virtues of doing that? Well, each of these hand calculations works fine for one set of hypotheses. You know, I think there's a 20% chance that the jury is going to give me X and a 30% chance that the jury is going to give me Y and a 60% chance that they're going to give me Z. I can work that calculation out by hand. But the problem is I haven't got good information. I don't really know whether the jury is going to give me 20% on X or whether they're going to give me 30% on X. I need a tool that enables me to run multiple calculations so that I can determine a couple of things. One, I can determine how robust my model is. If I get wildly different results from each set of calculations, then I know that my model's not very good, right? Because it's going to blow up. I could make a very bad mistake fairly easily. On the other hand, if I run a series of these calculations and they all cluster around a fairly defined set of choices, then I can be confident that my model is not going to lead me too far astray. So where do you get these probability data? Well, you get some of them in bigger jurisdictions from jury surveys. You know, in New York City, with the right amount of money, it's entirely possible to go to some service and determine what the loss of a leg is likely to be worth in a traffic accident case in the borough of Manhattan. There's remarkably little of that data in West Virginia. right? Or in any other small jurisdiction. So essentially what people are doing is they're making guesses. They're educated guesses. The more somebody's practiced, the more they've got a sense of what a thing is likely to be worth, but they're guesses nonetheless. So you don't want a model that's going to throw you way off, because it's worse than useless, right? If you've got a model that, by plugging in various results, you get wildly different calculations, it's spurious precision, right? It gives you a very precise answer, but that answer can be precisely wrong. Right? So it's really key to use this kind of methodology in the law practice setting to be able to test the model. And the only way you can test the model, unless you really want to just spend your entire evening filling out calculations by hand, is to use a spreadsheet. All right. And this happens to be a spreadsheet capture of this same problem that I showed you on the decision tree. It's key, of course, with every spreadsheet, that rather than plugging in discrete numbers, you use formulae, so that you can, by changing the underlying numerical assumptions, you can rapidly recalculate. All right. So this is what I'm trying to teach students how to do. Linked off of this website is a series of tutorials that basically takes them through Spreadsheet 101. You know, put the number here, put the formula here, and enables them to, hopefully, generate one of these tables with respect to computing a BATNA. Now, you can, and in fact, most people who teach negotiation simply do this. You can give them the assumptions. You can say, your client has said that they want to settle for X. Or the senior partner says that if you go to trial, you'll get Y. And if what you want to do is focus simply on the skill of negotiation, that is, given those assumptions, how good a deal can you get, that's fine. But it's only half the battle. Because when they get out into practice, what the client's going to say to them is, hell, I don't know, that's why I came to you. All right? You tell me what this case is worth. Or even worse, my Uncle Charles had a case just like this, and his lawyer got him X and such. All right? So they need to learn the skill of negotiation, but they also need to figure out what they should be negotiating for. And that's what this piece is designed for. Let me stop there and ask first, does anybody and I think I know the answer to this, does anybody at your school teach negotiation? Yeah, I don't think there's a law school in the country that doesn't have some negotiation stuff being taught. Is it taught in a simulated setting, that is an interview and counseling and negotiation class, or is it being taught in a standalone negotiation class? What do you think? Okay. The world needs to hear you.
Marshall, it's combined.
Okay. With interviewing and counseling?
Yeah, mediation is separate, but I think the other
Right. Yeah, interviewing, counseling, and negotiation is pretty common course in law school. Did you have a different?
I think we have both at Cincinnati, Marjorie. I think there's a course that is just negotiation, and then there's also, it's a subpart of a broader course on client counseling.
Okay. All right. Other different models? I guarantee you that all of your clinics are trying to teach some of this, right? Even if it's a business clinic, they're trying to figure out how to negotiate with another partner, with a potential vendor. If it's a litigation clinic, they're trying to figure out how to do a jury plan or an assessment of a particular judge and how the judge is likely to react to certain kinds of things. And few of them are going to be emphasizing this piece of the calculation. So there is something you can bring to them that is likely not to be stuff that they're doing right now that would be helpful to them using this kind of model. Other thoughts or reactions? Did I see your hand going up, or was that just a vagrant back row? Okay. Yes?
I'm just curious, is that part of it one class, or how much background do you find that the students have in terms of using spreadsheets?
They have very little spreadsheet background unless they come out of we have some engineers, right? We have some folks who did science and math undergrad. But the vast majority of and we have some business people, but the vast majority of our students have precious little exposure to spreadsheet use. It's not exactly rocket science, so it is possible to teach them relatively quickly. And we use it in our clinic in two settings. We use it in a class that I teach on negotiation, in which this problem comes out of that class. And we also use it in real life in assessing our cases, particularly ones that are likely to end up in trial, particularly ones that have potential money judgments. Equity is a little harder to fit into this kind of model unless you want to put a number value on your equitable result. But we do enough cases where there is some dollar value that this is a useful thing. If you do a lot of consumer stuff, that's a litigation setting in which this is particularly useful. Not many clinics do a lot of personal injury. So, that's the model that gets most used in terms of this. Okay? Other thoughts or reactions? All right. Okay. And again, the contact information. All right, so we've got negotiation. Let's talk about interviewing. The spreadsheet, obviously, virtually every computer comes with Microsoft Excel. If you're an open source school, OpenOffice has a fine spreadsheet program, Quattro Pro. I even know of one school that is clinging to Lotus 123. Go figure. Okay. When we're talking about timelines, however, There's not much out there. Microsoft makes a product that they call a timeline template, but you really have to do almost all of it by hand. So it's not all that much help to you. However, my guess is that pretty much everybody here has LexisNexis. If you have the LexisNexis contract, you have free for your students' use a series of products, one of which is called CaseMap. Tends to be overkill for simple cases, very useful for complicated cases. But a sister program to CaseMap is TimeMap. And TimeMap is useful in all kinds of cases. Big cases, little cases, doesn't matter. All right? And as I say, free to your students. Not all that expensive if they have to pay for it once they get out into practice. A standalone version is, I think, under $100. And obviously, if they've got if their firm has a LexisNexis contract, they can get it as part of that package. One of the paradigm models of interviewing is to try to get from the client an orderly timeline of the events which give rise to their problem. This is much more difficult for most clients to do than seems self-evident. People tend to bounce around as remember things. And it also is something that lawyers have some difficulty doing because there's a tendency to get so fascinated with the minutia of a particular part of the problem that they never see the whole problem. As a result, they find out things at trial when their client gets asked a question that they neglected to ask. This is very unsettling. You want to know what your client's going to say before you walk into the courtroom. So using TimeMap, either during the client interview or for the students subsequent to the client interview, going back through and trying to reconstruct their notes, can be very useful. And basically what it is a program that lets you just put in a series of date, time, and fact, and generates for you a pretty little picture of that information. So I entered the fact that this particular client picked up a file on date X, let's see, May 12th of this year. Okay. That's nice. But what it does in addition to that, here we have a second fact. The client didn't bring the file back. But I want to draw attention to that second fact because it's a problem. Right? So the default is that blue screen, but I can easily change that to red. Okay, so now my timeline flags for me that we've got a problematic area here. Okay, you will notice that because the first event took place at about 10 o'clock and the last event took place at about 4 o'clock on the same day, the timeline is pretty expansive. It assumes that I'm working hour by hour. But if I give it another piece of information, in this case, that the client ultimately did return the file several days later, what it'll do that almost no other program will do is it'll rejigger your timeline. Okay? So I didn't have to move these two events closer to each other to make room for the new piece of information. All of this is done by the template in the program. That makes it much, much easier to construct a timeline. I mean, that little piece of differentiation is the difference between essentially doing this in Word and doing it in this kind of document. Because no matter how many facts I throw at this thing, and I've got timelines that stretch for, several pages and represent several years' worth of activity, it will automatically put them in the appropriate relationship to each other. And that's the genius of the program. Very useful, say, to help people get a sense of the order in which things happened and the relative, by using the flags, the relative importance of these events. So, for example, if we wanted to conduct a further interview with the client about why the file didn't get returned when the client said it was going to be returned, I've given a visual cue to myself or to the student or to whoever that that's something we need to follow up on. If, as is pretty common in client interviewing, you see large gaps in which something must have happened, that can be particularly helpful in structuring a subsequent interview. Or if you're doing this while the interview is going on, gives you a cue that you need to be following up with the client about what the difficulty is. Again, most of you are, sounds like working at schools where you have a simulated interviewing, counseling, and negotiation. So your students in the simulation are confronting this problem, and I will guarantee you that every clinic you have at your school has got students who are trying to come to grips with the problem of how do I extract from a client a coherent story about whatever the event is, taxes, business, litigation, domestic violence. Does not matter. The skill is the same across all of those disciplines. Anybody got it? Well, let me take your question first and then.
Actually would suggest that they have this open and be taking the notes into the timeline as the interview occurs.
I have a demo on the website of doing that. I think there are some pluses and minuses. If the client finds it off-putting, obviously it's a bad idea, right? Clients are at all different levels of familiarity with technology, and that includes clients in your clinics who are pretty poor. The technical divide has, I don't want to say totally gone away, but been ameliorated with exposure of kids in schools to technology, so that clients no longer, the digital divide no longer freaks as many people as it used to. But clearly, particularly on an initial interview, if the client finds this off-putting, it needs to be put away. On the other hand, if the client doesn't find it off-putting, it almost provides a neutral focus for discussion. People, as you can readily imagine, coming to a lawyer are typically coming to them because they're in trouble of some kind. Folks don't waltz into my office and say, "It's a wonderful day in the neighborhood," right? They come to me because they've got a problem they want to get solved. And sometimes, in fact, frequently, that problem is embarrassing. There's something about it. They feel they messed up. They, things that they had hoped for, their marriage, whatever, isn't going as well as they wanted to. It's sometimes hard to sit across from a stranger and be completely frank about that situation. And this sort of externalizes the problem in an interesting kind of way. So I think that's a judgment I'd make on an individual. But even if you didn't use it during the interview, you could certainly use it post the interview to see where your problems were. Other thoughts or questions about that? Anybody use MindMap in your schools? Yeah. Okay.
I've used it for...
What do you use?
I teach legal research and writing.
Okay.
And I've incorporated a couple times where there were particularly difficult factual situations just to give the students a tool to sort out who did what to who, when.
Okay, so it's a demonstrative aid for your students in terms of picking up on the facts of your hypothetical case.
Correct.
Okay. Other uses that people have made of this? Again, this is something that I've used fairly extensively in real-life contexts, both in the clinic and in other settings. And as you point out, the more complex the fact pattern, the more utility you get out of this kind of structured approach. You can also use other kinds of structuring devices like mind maps and that kind of thing. But particularly in interviewing, there's a unique benefit to timelines because almost all stories are well understood in terms of that kind of chronology. It can also be very useful, and you might suggest this to your clinicians, in terms of telling a judge. The same benefit that you get out of it with them setting out the facts, they could use in a particularly complicated set of facts, to say to a judge in opening or closing statement, this is the timeline on which things happen. This is why we know that certain events occurred because of either prior or subsequent events. Okay, good. Other thoughts? Anybody use case map? A much more complicated case map, much more complicated program. Really, its utility lies in very fact-intensive, very paper-intensive cases. We seldom have a case in the clinic that merits a case map approach, although we did a piece of federal litigation this spring that it was helpful in. But I've used it in my own work fairly extensively on fact-intensive kinds of materials. Okay, so we've done negotiation, we've done interviewing. How about counseling? The core problem in counseling is that people don't think of enough choices. And then once they think of those choices, they don't know how to structure, right? So you got too many, initially too few options being identified. And then if you push past that, too many options to properly evaluate. So this is a situation in which, to go back to your question, I find some kind of picture for the client extraordinarily helpful. right? And you can do it by hand on a whiteboard. You can do it using software in a mind mapping situation. Okay. There are web-based free mind mapping utilities. The one that I favor the most is not free. It's a commercially available option called Mind Manager. Comes out of Germany, but it's it's huge penetration in the U.S. market. Any one of those will work for this purpose. What I'm going to illustrate for you is Mind Manager. Okay, so we've got a client, mother in a custody case, trying to evaluate what are the best options for her child, or in this case, children. And what should she be asking the other side for? What should she be seeking through litigation in the courts? What choices does she have? The reason I like Mind Manager as opposed to some of the other ones is that it enables you to go into brainstorming mode. Okay? And what that mode does is just let you generate bing, 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 bing choices without putting them in any order, without giving them any preference. Just clear your mind and give me everything you can think of. Right? This is very useful in the counseling situation for the reasons that I've already discussed. It's also useful in thinking about litigation. What causes of action might we pursue? What witnesses might we interview? What situation that involves generating a lot of free-form thought in a hurry. We use it in a litigation planning context in which we're trying to get students to think of all of the possible sources of information that could exist on a particular problem. Okay. Once each alternative has been identified, and this should, by the way, be an iterative process between the lawyer and the client. That is, the client ought to go first in terms of thinking of all the options that, in this case, she can think of, and then the lawyer ought to backfill with options that the lawyer can think of. There are situations in which it might make more sense for the lawyer to go first, although most of the time in the counseling situation, you really want it to come from the client as much as possible. But once each option is generated, then you want to do pros and cons. What are the advantages of that option? What are the disadvantages of that option? And again, the mind management tool enables you to do that. So, for example, here's an option this mother has identified. She could try to negotiate with the father to return the children. Rather than starting out with a litigation option, she could try to do a negotiation first. And what would be the advantages and disadvantages of doing that? Okay, so moving on to another option, she could leave them with Dad. Okay, what would be the pros? What would be the cons of leaving them with Dad? Well, Dad's better off economically. So leaving them with Dad might get the kids more in the way of kid kind of stuff. They're currently in school in another jurisdiction. Leaving them with Dad would be less disruptive to their schoolwork. Leaving them with Dad would be less disruptive to their schoolwork. Leaving them with Dad would be less disruptive to their schoolwork. Leaving them with Dad would be less disruptive to their schoolwork. Leaving them with Dad would be less disruptive to their schoolwork. Leaving them with Dad would be less disruptive to their schoolwork. Leaving them with Dad would be less disruptive to their schoolwork. Leaving them with Dad would be less disruptive to their schoolwork. Leaving them with Dad would be less disruptive to their schoolwork. Leaving them with Dad would be less disruptive to their schoolwork. Leaving them with Dad would be less disruptive to their schoolwork. Leaving them with Dad would be less disruptive to their schoolwork. Leaving them with Dad would be less disruptive to their schoolwork. Leaving them with Dad would be less disruptive to their schoolwork. Leaving them with Dad would be less disruptive to their schoolwork It might also give mom a little breather to get back on her feet. Right now she's in a tough place financially, and part of that's because she's trying to take care of these kids on a limited amount of money. Having dad take care of the kids might help her. Okay. Most of these, right, are not legal in the sense that they're not something that a lawyer has particular expertise in. Economics is something that is probably at least as pressing for mom as it is in terms of the lawyer's calculus. But it's this counseling notion of a mix of law-related questions and non-law-related questions that makes the evaluation piece particularly difficult and interesting. You know, a lawyer might well look at this problem and say, hey, he violated the court order. This is a simple problem. I just need to get that court order enforced and get these kids back. And if you were just looking at it through that lens, that might be the solution that a lawyer would come to, which might or might not really meet the needs of the client. So forcing this kind of analysis of all of the choices is a useful exercise both for the client and for the law students who tend to be fairly unsophisticated, and once they see something that looks even vaguely like a nail, want to bring down the hammer on it without thinking about whether that really is the best outcome. There are obviously disadvantages as well. It'll be harder to enforce the court order later on, the more time she leaves them with dad. The client is currently subsisting on temporary assistance to needy families. You can't get temporary assistance to needy families without kids. So she may lose her economic lifeline, and she just wants the kids back, right? I mean, that's not an economic concern, that's not a social concern, that's what she wants to do. Okay, so what we get out of all of that, and I've only elaborated the pros and cons on that one option, identifying the pros and cons on each of these, and then giving the diagram to the client and basically saying, look, what I want you to do is I want you to go home. I want you to look at this. I want you to think about anything else that we might have left out. And then I want you to tell me what you want to do. Right? Frequently in legal counseling situations, there are not wonderful options. It is for precisely the same reason that people come to us when they're in trouble. It is a choice between the not so good and the less not so good. Right? So these are extraordinarily difficult decisions for clients to make because, you know, you're not holding out the gold ring. And anything that helps the client structure their thought process about that and really look hard at, you know, if I do this, this is what's likely to happen, can be extraordinarily helpful in terms of work with clients. Would I use the technology to generate the map? Probably. I mean, this is a clearer case to me than the interviewing case because I'm going to want to capture this data somewhere on a board or on a piece of paper or somewhere. And this is a really easy tool to use to do that. It also has the same advantage I identified before of externalizing the problem. It's not me giving the bad news that there are downsides to every choice. It's a discussion process that goes back and forth, and the bad news is being given by the display rather than by me as the individual. But I think that it's an easy tool to use and quite satisfactory for the purpose that I'm using it for. Yeah.
Does this software allow you to do color customizing and jazz things up a bit?
Yes. Okay. Yes. I've just shown you the plain vanilla text version. You can put little smiley faces by things that are good. You can put red flags by things that are bad. You can also use it as a hypertext linking tool. So if you want to, link out to a Word document or a if you need more space than the little space here, you can do that as well.
Or any possible little pictures that you can insert or anything, to be very Tony Buzan about it?
Yes. It comes with a whole series of icons that you can use, and you can use another picture and import it and use that as an icon as well. So yeah, the more, in those of you who've read sort of the literature on mind mapping, it tends to be a much more graphic process than I've illustrated here, and you can make this much more graphical than I've illustrated. I use this occasionally as support for a lecture. You can step through this in lecture kind of mode or PowerPoint kind of mode. And when I do that, I put in lots of graphics about, why each item that I'm talking about. Okay. Anybody using mind mapping in your schools? Anybody know of any faculty?
Yeah, we've used this a little bit in conjunction with the LexisNexis Concordance and simulation. We did a pretrial litigation course with a focus on e-discovery.
Okay.
Where in the fall, students created a body of work, and then in spring had counsel looking at two sides and used concordance for a body of several thousand email messages and a handful of native documents, and then produced, for opposing counsel. And from there, found we just barely started looking at this, that you could then import documents into CaseMap as you're mapping it out, so you can actually link to the documents that you produced for each other, which was really neat.
Okay. All right. This is not CaseMap. This is Mind Manager, but yes, CaseMap would be extraordinarily helpful in that kind of setting. If you wanted to do a complex litigation simulation, and you wanted to have, most of the hypothetical files are not rich enough, but NITA has a couple of their real high-end hypo files that do have enough documents to make CaseMap a useful tool. Other thoughts or reactions? Okay. All right. Well, any other, since we've got a few minutes left here, any other technologies that you know that your clinics are thinking about or that your simulation teachers are thinking about that you'd like to get some reaction to, since I pay a fair amount of attention to that kind of stuff? Anybody coming to you and saying, hey, or anything that you've run across that you think they ought to be asking you about? Yeah.
I'm curious if anyone is using or is aware that their school is using the the video trial network through audio case files, just in terms of representations of trials for teaching trial techniques.
Okay. So this is something along the same lines as the Oyez Supreme Court argument software, or is this a different?
Audio case files has a separate where they essentially break down trials. So there'll be a discussion of examining witnesses, and they'll show you an examination. And
okay.
Our library is using Courtroom Connect.
Yeah,
That's made by the same
I
company.
think that's the outcrop.
The posterity would want me to tell you to use your button.
Our library was using Courtroom Connect.
Okay. All right. There's a real old set of simulations. It was originally done at Harvard, and then it went to Stanford, and now PLI owns it, and they've pretty well killed it. But
Actually, John told me that Scott is trying to bring it back.
is he? Well, I'm probably the only law school in the country that's currently using the existing version. It's a very good direct and cross. And the reason I use it is it has the ability to do evidence objections.
What's the name of it?
PLI puts it out.
Just do a Google search for Olney v. Maryland video, and that'll probably bring it up.
Okay. Yeah.
Olney v. Maryland, I think, was one of the cases in it.
Yeah, this one is it's kids with a rock star contract. Ronnie Fox versus something records, Roundtable Records. Okay. Other people using other tools? Yes.
I have a question. Is anybody familiar with a piece of software called Clio or Clio? Is anybody using it?
Okay.
I'm Joe Gray from the University of Tennessee, as it happens. We have been using a piece of software called Needles for some time on top of a side-based database, and it's very limited in that you have client application that has to be installed on your workstations. And we're looking at some alternatives and found that I believe Georgia State was doing a pilot with Clio there in Vancouver. And it's completely browser-based, frees you up from being tied to a particular workstation or having a client application installed. And we started a trial of Clio as well, and use it. It's really more of a management piece of software, really. You use it for context databases, conflicts checks, calendaring to figure out, when you need to renew trademarks. But yeah, we've been talking to them and seeing how it can be tailored to what we want to do. It's been pretty successful so far.
Yeah, the most commonly used software in the clinic setting is a case management software. And by and large, what clinics are doing is using one of the commercially available systems. So Amicus and TimeMap are the two biggies. Time Matters is now owned by LexisNexis. You can see what?
And over the last few years, they've rebranded it several times. The last time I saw it, they were calling it front office, and they were calling the accounting billing part of it back office, or vice versa. I can't keep it straight. But we all still call it Time Matters.
Yeah. That's actually the one we use. Amicus has a nicer interface, but has a problem that you can't use it across multiple machines very effectively. So if a student wants to be able to use another machine in the clinic, which ours frequently do, they can't get access to their Amicus stuff, which is a real pain. But nationally, among law firms, it's about 50-50 as between those two programs. There are some also rans like Practice Master and that kind of thing, but those are the 100-pound gorillas. And I'll wager you that virtually every clinic has some kind of system like that for the reasons you've identified. Conflicts checks, document retention, that kind of stuff. Billing, a lot of clinics use a time capture function even though they're not actually billing clients. Okay. Other thoughts or reactions? Okay, well, I guess that does it. Thank you.
TMI. Have a good evening. You too, right? Thank you, Marjorie. That was really interesting.
Well, thank you for coming.
That use of a mind mapping, and I was familiar with Mind Manager. I've played, with MindJet, MindMap. And
Right.
that
Well,
ability
MindJet actually is the company.
But they also have a product.
Yes, they also have a somewhat lighter weight.
MindMap.
Right.
But Mind Manager, that ability to just list